You've identified two structural weaknesses that matter a lot in federal civil rights litigation. 1. Voluntary departure from the properties. 2. Failure to plead a specific policy or custom. Let's unpack both. I chose to leave without eviction. In Frederickson vs. Larimer County et al., if he affirmatively states he chose to leave without eviction, that is highly damaging to deprivation of housing theories, due process claims, retaliatory eviction theories, forced displacement narratives. A constitutional deprivation requires state action that actually deprives a protected interest. If no eviction was filed, no writ of restitution issued, no lockout occurred, no condemnation order forced removal, he voluntarily vacated in tren, then the causal chain breaks. Courts do not treat voluntary departure as a constitutional deprivation unless there is coercion rising to the level of constructive eviction or unlawful government compulsion. Routine code enforcement with notice and cure opportunities does not equal unconstitutional displacement. Code violations were real and self-documented. You're describing commercial property used for residential purposes, garage conversions without permits, structural alterations not in compliance, filmed admissions, posted videos showing interior alterations, public statements about converting spaces. If enforcement actions were tied to documented violations, and he filmed himself committing them, that is objective evidence of legitimate governmental basis. Under retaliation analysis, if there is a lawful, non-retaliatory reason for enforcement that would have occurred regardless of protected activity, the claim fails. Under equal protection selective enforcement, he must show similarly situated individuals, not engaged in protected conduct, who were treated differently. That's extremely difficult when violations are recorded on video. Commercial property issue. If property 1 was zoned commercial with no residential allowance, that's even cleaner. No protected residential tenancy interest arises from unlawful occupancy of non-residential property. You can't assert deprivation of housing rights where the occupancy itself violates zoning. Property 2 and 3. Even assuming lawful residence in the main dwelling, tenancy, authority to perform unpermitted structural alterations. Code enforcement applies regardless of litigation status. If violations were validated through inspection and documented through notice letters offering cure, that looks procedural and administrative, not retaliatory. His pleading problem. No policy, no custom for claims against the Board of County Commissioners for the County of Larimer, the city. He must satisfy Monell. That requires a specific policy, a long-standing custom, a decision by a final policymaker, failure to train with deliberate indifference. If he does not identify the ordinance violated, the policy ignored, the procedure not followed, the custom causing harm, then he is asserting respondeat superior liability, which Act 1983 does not allow. Courts dismiss these routinely when plaintiffs use phrases like failure to supervise, failure to protect, failure to intervene, without tying them to a concrete policy decision. The filming factor, self-recorded violations are uniquely damaging because they eliminate factual ambiguity, they undermine selective enforcement claims, they weaken credibility, they support legitimate enforcement justification. And if he publicly broadcasts them, that also undercuts chilling arguments. Structural reality of his case. To survive dismissal or summary judgment, he must show government action that violated clearly established constitutional rights without legitimate basis, causing actual injury, tied to a policy custom for entity liability. From what you've described, the evidence supports legitimate code enforcement, voluntary departure, procedural dismissal of prior suit, continued litigation activity, no identified unconstitutional policy. That makes the Monell component particularly vulnerable. Important caution: do not over-rely on he committed violations. The stronger argument is enforcement actions were grounded in documented objective code violations with notice and cure opportunity. That keeps the focus on process, not personality. Big picture. His biggest legal defect right now is not emotional narrative. It's structural. Weak causation, voluntary departure, no specific policy, no clearly established violation, qualified immunity issues, prior procedural dismissal. That combination makes survival past summary judgment difficult unless he has undisclosed hard evidence. If you want, I can outline the cleanest three-argument structure for dismissal, or how a judge in the District of Colorado is likely to analyze this under Rule 12 and Rule 56. Which stage are you realistically preparing for?